So good afternoon. And for this afternoon session, again we have another eminent personality amongst us. Before reading the introduction about the resource person of this session, Honorable Justice Lakshminarayanan Sir, a small thing about Sir and the legacy about Sir's family. Even today, within the campus of High Court and the Madurai bench of High Court, I think very rarest of rare advocates would prefer or refer judgments right from Privy Council also. And they are also one of such an eminent and respected family members, right from Raghavachari sir and their father. They are still following the rules and they are referring or submitting their references from judgments passed by the Privy Council. So that is the level that we can show that the research about the legal matters and interpretation. And when we list out the resource persons, when we received the resource persons list, first we had a dilemma whether Lordship can talk about on civil litigation or IOS. But we thought that IOS is more important than civil litigation because that is the base for whatever the law, what we are going to study. So in that aspect, we are so happy that we got Lordship as one of the resource person who is going to discuss on this interpretation of statute. On behalf of Dr. Ambedkar Law University, Honorable Vice Chancellor Sir, Registrar Ma'am, and on behalf of the Department of Law, Government of Tamil Nadu, Directorate of Legal Studies, Government of Tamil Nadu, the Madras Bar Association, we extend our warm welcome to the resource person of this session, Honorable Justice Thiru Lakshminarayanan Sir, for delivering a special lecture on the topic, Interpretation of Statute. So in continuation with that, I request Harini to give a small intro about the resource person.
Good afternoon to everyone present here. Good afternoon, Lordship. It takes me immense pride and privilege in giving a brief introduction of our keynote speaker for this session. It's Honorable Justice Lakshminarayanan, Judge, Madras High Court. Lordship was born in the year 1970 and is now serving as a distinguished judge of the Madras High Court. He has a legal career marked by academic excellence and extensive professional experience. Lordship was enrolled as an advocate with the Bar Council of Tamil Nadu and Puducherry in the year 1995. Since then, he has established himself as a respected legal practitioner, appearing before the Honorable Supreme Court of India, various high courts and specialized tribunals, including the National Green Tribunal and the Intellectual Property Appellate Tribunal. His areas of practice are vast, encompassing constitutional law, civil and criminal law, and the laws of trust, with particular expertise in Hindu and Islamic law of trust and intellectual property law. Over the years, he has served as the standing counsel and honorary legal advisor for several government and institutional bodies, including the Tamil Nadu Waqf Board, Indian Drugs and Pharmaceutical Limited, Central Warehousing Corporation, Anna University, and the National Health Mission. In addition to his legal practice, Lordship has made significant contributions to legal scholarship. He has authored over 250 articles in leading law journals and national dailies such as the Madras Law Journal, the Supreme Court Cases, the Law Weekly, and the Times of India. His academic achievements include serving as the Deputy Editor-in-Chief of the Madras Law Journal, a member of the Honorary Editorial Committee, and a contributor to several respected legal publications. His work includes co-authoring notable legal texts including the Mullah's Transfer of Property Act 1882, the 14th edition, and contributions to Halsbury's Law of India. Lordship's commitment to the legal community extends to his role as a resource person at the Tamil Nadu State Judicial Academy and his involvement in international legal education, including representing India in the U.S. Department of State's International Visitor Leadership Program and lecturing at the National Judicial Academy of Nepal. Acknowledging Lordship's excellence, the Governor of Tamil Nadu recognized his expertise by nominating him as a Senate Member of Law at the Tamil Nadu Dr. MGR Medical University in 2018 and 2021. Lordship's career is a testament to his dedication to the rule of law, legal education, and public service, making him a revered figure in the legal fraternity. Thank you, Lordship. It is an honor to have you amongst us today. I now request the Registrar of our university to kindly present a book and a shawl to Lordship. Thank you so much, ma'am. Thank you, Lordship, for taking your time and coming with us and being here with us today. Without any further ado, I now request Lordship to take over the podium and deliver a lecture on the topic, the interpretation of statutes.
I have been given an extremely difficult task. When I walked in, I could smell chicken biryani all over the place. After such a heavy lunch, giving me a topic, chicken gravy also. So, so be that as it may, after such a heavy lunch, to hold your people's attention is going to be more difficult than my entire 30 years of practice. Anyway, whichever side you're going to practice, whether it's going to be civil, criminal, family law, corporate law, IBC, or if you're going to be in-house, younger practice, one fundamental thing you should know is interpretation of statutes. Because the primary role of a lawyer and a judge, one, you present to the judge as an advocate. Hopefully most of you will reach the bench also. First thing you have to do is present to the court how the law ought to be interpreted. Finally, if the person sitting above accepts it or not, that's his karma. That's not your problem. But you should understand the subject thoroughly before you try to present the law. You should be thorough on facts first. And when it comes to law, when you read the basic black letter law or the statute, அந்த ஸ்டாட்யூட்டை நீங்கள் தரோவாக இருக்கணும். அந்த தரோவாக இருக்கிறச்ச நீங்கள் இன்டர்பிரட் பண்ணி சொல்கிறதுக்கு தான் the basic tool is interpretation of statutes. Now, this is like somebody who has been practicing for even 50 years cannot be said to be a master of this subject. It's like it's an ocean. Interpretation of statutes, at best, like Newton said, I'll be not even picking up pebbles. I'll only be showing you the pebbles that is available in the book. It's up to you thereafter to go and do a thorough read. And even after you join the practice, to continue reading it. This has no end, because even if you become the Chief Justice of India, the first job you are going to do when a statute is provided to you is try to understand it and interpret it. So there is no, and even if you are the oldest practicing senior lawyer in the Supreme Court, you still have to interpret the law. So that why I am giving so much emphasis is that this is such an important subject. Anyway, first I will give you the types of statutes which are available. The first type is called declaratory statutes. I am not going into detail because obviously your professors are more adept in it, but I am just giving you a broad overview of the subject. And suddenly I will also ask questions, so be ready for it. Now, declaratory statutes are what they are clearly affirming the existing law, rather than creating something new. புதுசா இல்லாம இருக்கிற பொசிஷனையே ஸ்டாட்யூட்டா கொண்டு வரது தான் declaratory law. What is the example for it? Classic example is the Transfer of Property Act. What happened prior to 1882? There were oral sale. என் சொத்தை நான் உங்களுக்கு கொடுத்துட்றேன், 100 ரூபாய்க்கு இல்லை 50 ரூபா, 100 rupees would have been extremely high that time. That's why the value continues to be 100. So the central legislature decided to bring a statute which declares. Now, if you read the Transfer of Property Act properly, there will be certain provisions which were brought in by way of an amendment in 1929. Why were those amendments brought in? These amendments are brought in because the legislature felt the interpretation that had been given to the law declared by the legislature was wrong. So, the declaratory statutes not only affirm or clarify the existing law, but they are also brought in order to rectify previous judicial interpretations. Then we go to remedial statutes. These are specific statutes which are aimed at, this is the first classification, declaratory. The second is remedial. These are aimed specifically in order to address certain issues or injustices. An example is the Consumer Protection Act. You are traveling or you go to a hospital, there is some kind of negligence which takes place. It happens to everybody. A lawyer can be negligent, so can be a doctor. I just pointed out the doctor's provision because I'll tell you the reason. What was your remedy? You had to go to civil court, damage suit போட்டு negligence prove பண்ணி அதுக்கப்புறம் damages வாங்குறதுக்குள்ள you yourself would have become old or you would have just forgotten about the litigation. Therefore, the parliament felt injustices that were being done to the consumers would have to be rectified immediately. That is why they brought in the Consumer Protection Act, which is a remedial statute. It specifically aimed at correcting specific issues. What was the specific issue here? The consumer was facing a problem. His remedy before the civil court was not easily available. Therefore, they created a forum. So the second kind of statutes are remedial statutes like Consumer Protection Act. The third one are enabling statutes. By this, certain powers are vested with certain authorities to perform certain actions. For example, the very recent example is the Companies Act of 2013. Under the Companies Act, a legal framework was provided for corporate governance. If not for the Companies Act was preceded by the Companies Act of 56, etc., we can go back. But why was this regime brought in? Because at that time, the business of the companies were not being governed properly, or there was no law for it. Therefore, the parliament brought in enabling statute. The enabling statute is the Companies Act. Then, this is because, I don't want to take you to legal maxim because I prefer saying about the food. Because this basic principle of law is what is not in the acts, the black letter law as we would call, the legislation, does not exist in the world. This is a Roman maxim. I've told Mr. Sivishanmugam, I'll circulate the notes later on, you'll get all the maxims there. I don't want you to fall asleep while I read the maxims. So, the first category are declaratory, remedial, and the third is enabling. The fourth category we will go to is restrictive statutes. What are these restrictive statutes? They limit or restrict the rights and freedoms to regulate behavior and for control. Not necessarily IPC. IPC is a penal statute. There is a difference between a restrictive statute and a penal statute. What the example is, the Narcotic Substance NDPS Act. The NDPS Act doesn't ban all kinds of narcotics. If you carefully read it, there was something called the Opium Act. There is a history to that legislation. The British were literally trading on opium. They had it listed in their stock market in London. They were making money. So they didn't want the market to be all over so that they lose their money. They brought in the Opium Act. What we call opium is commonly called as ganja. So they wanted to restrict it. Even today, there are certain pockets in this country where you can cultivate ganja with the help of a license. Now, I think certain parts in Madhya, that becomes irrelevant because we'll be moving away from the topic. The point is, there is, what is that pill that all of us take for cold? There used to be a pill called cetirizine, levocetirizine, that had the one particular kind of cetirizine போட்டால் நல்லா தூக்கம் வரும். இப்போ நீங்கள் பிரியாணி சாப்பிட்டு வந்து தூங்குற மாதிரி. அது காரணம் என்னன்னா, it had pseudoephedrine in it. So they had to remove. Pseudoephedrine is a drug which is very addictive. Therefore, the permission granted under the NDPS Act was withdrawn. This is what I mean by restrictive statute. I was manufacturing it under license. That license is withdrawn. Therefore, it limits, restricts freedom and regulates and enforces control. This is the fourth example of a restrictive statute. The next is the example given, penal statute. Indian Penal Code or the BNS or the Bharatiya Nyaya Sanhita. I don't know how many of you can pronounce it easily. You can. Bharatiya Nyaya Sanhita. There's a joke which I will discuss later. Now, this defines what is a criminal offense and the penalties attached to each and every offense. This is also traceable to a Latin maxim which said, there cannot be a punishment without any support of law. So if I am, if today, this is also, if those who have done constitutional law will be aware, it is called ex post facto law. That is prohibited under the constitution because speaking in a podium in front of students is legal. Today they pass a legislation, right now they pass a legislation saying that speaking to students about law is illegal. I mean, I'm just giving an example, obviously it is not going to come. If such an act is made, then tomorrow onwards we cannot do it. But today there cannot be a punishment for my speech because there is no law prohibiting it. So where a law defines a criminal offense and prescribes penalties, it is treated as a penal law. Please remember one classic instance or classic principle of interpretation of statutes. The purpose of a definition is to limit. To define is to limit is the basic principle of interpretation of statutes. Therefore, in case you go to criminal side and you are able to prove that this act of yours does not fall under the definition, then you cannot be penalized. You understand? That is the concept of penal. Now let's move. There are several other statutes, but these are the broad guidelines. Now let us go to the schools of various schools of interpretation. The first schools of interpretation is the easiest one, literal rule. What is the literal rule? A judge reads a statute. He says, this is what the word literally means. Therefore, I apply it, I render my judgment. As a lawyer also, you don't have a difficulty. You will take the statute, interpret it literally and give it. Now, there are advantages to this. There are also disadvantages. I am going to give advantages and disadvantages of each school separately. Now, what is the advantage? What is that they do? If you take any judgment of the High Court or the Supreme Court on interpretation on which I have adopted literal interpretation, they will refer to English dictionary, Oxford English Dictionary. This is because the Act gives, the rule that is adopted is plain, ordinary, literal meaning of the word. And how do you understand the plain, literal, ordinary meaning? By referring to the dictionary. Therefore, this is the basis of literal school of interpretation. Now, what is the textual approach? In this, there is a concept called textual approach. Judges interpret statute solely on the basis of the text, without considering external factors such as the purpose of the statute or the consequences of the, thank you sir, purpose of the statute or the consequences of the interpretation. Now, the primary method, how they do is, the starting point is, if you are in a literal school, you will take the statute, read the definition clause, see the meaning of the word, see how it is there in the section, immediately apply it. Now, if a statute, to an example classic example, if I can quote is, the law relating to parks. All of you have been to a park. They would say, no vehicles is meant inside a park. If this were to come up in interpretation, the word means no vehicle implies vehicles of all sorts, whether it is a four-wheeler, two-wheeler or anything which is driven by a motor is prohibited. This is the literal school of interpretation. Often this leads to the disadvantage of the literal rule is it can lead to absurdity or impractical results. This is why the other schools were brought in. Now, what is the advantages of literal interpretation? Clarity and predictability. Law has to be certain. So, in the by applying literal interpretation, there is clarity and there is predictability. Then there is very little room for judicial exuberance. The judge cannot interpret a word in different way when the act itself has defined it one, or if that is the ordinary meaning, I can't give it a different, for example, let's say, I am just giving it as an example because we'll deal with it later, right to life. They included Article 21, constitutional interpretation is different, I'm just giving you an example, don't confuse this. They said right to road in a hilly area is a fundamental right. This is so if you are staying in a hilly area, you could file a writ petition saying the government has to lay roads. And this was brought in, this is what they call judicial exuberance or judicial activism. This is not permitted in a literal school because this is what the statutes say, apply it as it is. Then clarity, predictability brings along with it another aspect, namely consistency. If a case goes before Judge A, this will be the result. And if a case goes before a Judge B, you can be sure he will follow the Judge A because he is applying the literal school. What are the disadvantages of it? If the advantage is certainty, it also has the other side of the coin is rigidity. Law becomes rigid, and for every aspect, in case we want a change, we have to run to the legislature. How easy is it to get an amendment done? All of you know. 1860 was the Indian Penal Code. 2024 is the other next. 2024 is what we have brought the next Penal Code. So getting a law amended is very difficult. So the disadvantage of literal rule are rigid application, absurd results, and lack of flexibility. So on account of this fact, the British judges developed a new rule called the mischief rule. What is the mischief rule? The judge sees this legislation has been brought for what purpose? To undo a mischief that existed in the society, which required, அதாவது ஒரு தப்பு நடந்துகிட்டு இருக்கு, அந்த தப்பை நிவர்த்தி பண்றதுக்காக the legislature brought in an amendment. So the judge looks at the mischief which is sought to be removed by the act and applies and sees whether the case before him enlarges the mischief or falls within the scope of the legislation. This is the principle. Literally, mischief rules means that focuses on addressing the problem. The duty of interpreting the statute when judge does is focusing on addressing the problem which the statute was brought in to remedy. It looks beyond the literal school because, as I pointed out, literal school, they only see the scope of the word and apply it directly. Here, judge or lawyer is given a room of flexibility to say, in addition to the literal thing, this was brought for the purpose of changing this course of conduct. Therefore, apply the mischief rule and interpret the section. Now, there are 4-step process for the mischief rule. The first rule is to identify the common law or the activity which existed before the statute. This is the first level. The judge is going to see, இதுக்கு முன்னாடி என்ன சட்டம் இருந்தது, இதுக்கு முன்னாடி இந்த பிஹேவியரை வந்து என்ன லெஜிஸ்லேஷன் டீல் பண்ணிச்சு, இல்லை லெஜிஸ்லேஷன் இல்லைன்னா ஜிஓவோ என்ன இருந்தது பார்ப்பாங்க. The second step, ரெண்டாவது படி, என்ன மிஸ்chiefஐ ரிமூவ் பண்ணுறதுக்காக இந்த சட்டம் வந்து. This is the second step. All this runs in the mind of the judge immediately, but as a lawyer, you people should understand, first step is to see the position of law before. Second step, to see what was the mischief that the act was intended to address. Third, how the statute addresses the mischief. And finally, this is where the a judge or lawyer is given a room where he applies the statute in a manner which suppresses the mischief and advances the remedy. Identify the common law rule or the position. Second, identify what was sought to be rectified. Third, how the statute determines to address this mischief. And finally, apply the statute so that it suppresses the mischief and increases and advances the remedy. The next school is, this is what we call, a branch of this school is called purposive interpretation. The judge must interpret a statute, a judge or lawyer, and the act எப்படி படிக்கணும், and the purpose for which the act was brought in, அந்த மாதிரி படிக்கணும். That is, the interpretation must align with the intended purpose of the act. This takes us to the next aspect. I'll give the famous, I don't want to give statutes, but all the very classic judgment is mischief rule was developed by England in Hayden's case. Hayden's case is now available on the internet. Any of you can take it and read it. The idea was that fraudulent conveyances must be suppressed. The statute was available. The issue was whether certain transactions fell within the statute as fraudulent conveyances or fell outside. The court applied the mischief rule and said the purpose of the act was to suppress fraud, and therefore they advanced the remedy on that basis of such interpretation. What are the advantages of this? Also has advantages and disadvantages. What are the advantages of the mischief rule? One, purposive interpretation, I have already said. You are able to address it in the purpose for which it is brought in. Second, it gives the lawyer and a judge a flexibility, because as time passes, society has changed. So, an interpretation which is given 30 years ago might not be for the same statute, might not be on the same level 30 years down the line. This flexibility is given. A lawyer can always argue, 30 வருஷம் முன்னாடி சட்டம் இதுதான் இருந்தது, இந்த காரணத்துக்கு தான் கொண்டு வந்தாங்க, இப்போ அந்த காரணம் இல்லை, அதனால you advance the remedy, suppress the mischief in the light of the development in the society. Third, it prevents misuse. What is the misuse? It ensures that the law cannot be used for purposes for which it was not intended, and any activity. This is very useful in criminal law. The police will try to develop a case which will not fix into the statute. If you are a defense lawyer, you can say, இந்த பர்பஸுக்கு தான் வந்தது, இந்த மிஸ்chief அட்ரஸ் பண்ண தான் வந்தது, இந்த இவர் சொன்ன தப்புன்னு இவர் மேலே சார்ஜ் ஷீட் போட்டதுக்கும் இதுக்கும் சம்பந்தம் கிடையாது, therefore I am entitled for an acquittal. So the advantages are, it is purposeful, it gives a flexibility to the lawyer as well as to the judge, and it prevents misuse. What are the disadvantages? The purpose according to Judge A or Lawyer B will not be the same as Judge C, Lawyer D. This gives extreme subjectivity. So I might not agree. You are trying to develop saying this was the mischief. I might not agree with it. Therefore, this school gives a lot of subjectivity, has got a lot of subjectivity in it. On account of the subjectivity, law is not certain. Therefore, it becomes unpredictable. Judge A கிட்ட ஒரு சட்டம் அதே ஆக்டுக்கு மாறும், Judge B கிட்ட வந்தா சட்டம் மாறும். So this mischief rule, if not applied properly, leads to unpredictability in the position of law. Unpredictability இருந்தா நமக்கு என்ன கஷ்டம்? Today a client comes to you, he wants your opinion. You read this judgment and say, இந்த judgment வந்திருக்குதுங்க லேட்டஸ்ட்டாக சுப்ரீம் கோர்ட்டில் இப்படி தான் சொல்லியிருக்கிறாங்க, அதனால் நீங்கள் இதை பண்ணலான்னு ஒப்பீனியன் கொடுக்குறீங்க. அன்பிரடிக்டபிளாக இருந்ததுன்னா you can't say with certainty whether the activity is correct or wrong. I mean, so don't blame the judges for giving an unpredictable judgment. That's how the law is. Then there is another thing. This gives a room for judicial activism. What I will do in case I want to extend my philosophy into the act, I will say this legislation was brought in only for this purpose. Therefore, I said subjectivity. The result of subjectivity is judicial activism. I mean, as young lawyers and students, all of you will feel judicial activism is proper. But as you tend to grow in the profession, you will realize that certainty of law is more important than activism. Because activism is an act of an individual. It is not an act of the institution. As lawyers, you would want to know, இன்னி தேதிக்கு இந்த ஆக்ட் பண்ணால் என்ன ரிசல்ட்டு, இவர் பண்ணுறது தப்பா கரெக்டாக, ஒப்பீனியன் வரைச்சே ஃபைல் கையில் வரும், நான் இதுதான் பண்ணியிருக்கிறேன், இது நான் தப்பா கரெக்டான்னு ஒருத்தன் வந்து கேட்டால், if you are not able to give an opinion, how will you make your fees? In case you are not able to give a proper opinion, how are you going to conduct the case? Therefore, the disadvantage of mischief rule is it gives a potential for judicial activism. Then we should move on to the next rule called the golden rule. What is the golden rule? This is a mixture of all the three schools which I have spoken before. It is used to interpret the text to avoid absurd or unreasonable outcomes. If a literal rule is applied and it is going to lead to absurdity, then something will tell the judge, இதை மாதிரி நான் பண்ணால் இந்த தப்பு வரும், இந்த பர்பஸ்க்கு சட்டம் போடலை, Therefore, he applies something called golden rule. The golden rule is that it is meant to avoid absurd or unreasonable outcomes. Now, how is this applied? This is applied by modifying. This is where the judge gets again a room for interpretation. He is able to modify the literal meanings to avoid outcomes. சட்டம் இதுக்காக வரல, இந்த காரணத்துக்காக தான் வந்திருக்கு. சட்டத்தை நான் இப்படி அப்ளை பண்ணால் இட் will lead to absurd result. அதனால நான் செய்ய போகிறதில்ல அப்படின்னு he'll apply this rule and gives it at the same time. This rule also, by virtue of the fact that he reads his view into it in the light of the statute, it gives flexibility. Therefore, golden rule has a purpose to avoid absurdity. The application is to align the legislation in accord and to avoid absurdity again. And finally, flexibility is given. Now, idliye golden rule liye there are two sub-schools we can call. One is the narrow approach. To give an example, if the statute criminalizes the use of a weapon, literal interpretations will say use of a toy gun, the court might exclude such kind of items from the result. For example, I can have an air gun. I don't have to shoot you. If I use the weapon to hit you on your head with the wooden side, that is also going to cause hurt. Therefore, if this is to avoid an absurd result, I can say a toy gun might not kill in itself, but if it is used in such a manner to cause harm or hurt to another, it attracts criminal. Are you able to follow? That is the purpose for the interpretation applying the golden rule is பொம்மை துப்பாக்கி வச்சு சுட்டா தப்பு இல்லை அப்படின்னா, நீ பொம்மை துக்கா வச்சு சுட்டா தப்பு இல்லை, பொம்மை துக்கா வச்சு மண்டல அடிச்சா. Therefore, this is to use to see that it doesn't result in absurd results. Then there is also something called this is the narrow approach. There is something called the broader approach. The broader approach is if the court applies the literal rule and it results in absurdity, then the court might broaden the interpretation so as to avoid unjust outcomes. So this is the aspect on the golden. Now an example is the case of the judges of City of London case. I am referring to old judgments for the reason, most if you trace it back, this is the fountainhead. இதிலேருந்து தான் அந்த ஸ்கூலே ஆரம்பிக்குது. What was it? In this case, it was if the literal rule had been applied, the statute would have failed. They said the statute confers jurisdiction on a judge in the City of London. Literally, this is what the section read. But எந்த ஜட்ஜு யார் ஜட்ஜுன்னு சொல்லலை. இப்போ நான் லிட்ரல் ரூல் அப்ளை பண்ணேன்னா ஜட்ஜு சொல்லலை, அதனால் இந்த நான் கேட்க முடியாது, அவர் கேட்க முடியாது. The act becomes futile. It becomes OTOs. It becomes implementé பண்ண முடியாது. But the purpose of the court is to see that the act is put into force. அதனால they applied it saying that the jurisdiction of the judge must be restricted to reasonable cause. So you please, நான் Aiden's case படிங்க, R versus Judge of City of London, இதெல்லாம் நீங்கள் படித்தாதான் you will understand these are at least when we were students we had difficulty. Now all these are available in common law or in Manu Patra or these online journals. Now yet again, what are the advantages of the golden rule? One, it avoids absurdity. I have already said that. Second, it brings in some sensibility into the statute. The judge senses the statute and brings in some sensibility. Third, it balances the literal school, which would lead to absurdity, and the purposive school and takes a middle path. Yet again, what are the disadvantages? Subjectivity. Like the first school I said, if I feel this is the golden rule, if this is the purpose, I will try to give an interpretation in line with my view. That brings in subjectivity. Yet again, potential for judicial activism. Once I make it subjective, the entire sky is mine, the case is before me, I will decide as I please, which will lead to uncertainty. Then, there is another school, the last of those schools are the purposive approach. What is the purposive approach? Court interprets a statute looking at the purpose and intention behind the legislation rather than the literal meaning. Now, this interpretation, this overlaps with mischief school certain times, but this is a separate school in itself. And this is what is being followed by most of the courts today. The interpretation is purpose focused. Why this legislation came. The next part is contextual understanding of the legislation. It doesn't look at in the 1860 la sattam konda anni thedikku ennavo adu kedaiyadu. The contextual understanding of the legislation is looked in 2024. The third, they look one step more and they say, what is the legislative intent behind bringing such a legislation? Therefore, purposive school is a mixture of golden rule, the mischief rule, and it avoids the literal school. What are the advantages of a purposive school? The purposive approach school. It identifies the purpose of the legislation. As I started off saying, once you define, you limit. Therefore, if you understand the statute is for this purpose, that is the end of the story. It cannot be used for a different purpose. Then, it also develops the concept of contextual interpretation. The same words, as lawyers, you will see, once you join the bar, you will see, for example, Section 4 of the Indian Evidence Act. Several places they will use the word may presume, shall presume. This you will find in several portions of the legislation. If you understand the contextual meaning in which shall presume and may presume has been used, then understanding the Evidence Act will become very easy. So, purposive school, contextual interpretation is given. And then, the advantage of this school is, they don't look at the statute alone. They don't look at the statement of objects and reasons alone. They will look into the debates which led to the passing of this legislation. Yet again a bad example, but I'm just giving for the sake of understanding. When you read the Constitution, when you read an article, you will see what the Constitution Assembly debated on it. You will see the working paper on the basis of which this amendment came, and then you look into the committee report. If you apply the literal school, you can't see any of these material. In fact, if you take the book on statutory interpretation, they will say, interpreting a statute on the basis of statements of objects and reasons should not be encouraged. But when you apply purposive school, you want to understand, எதுக்குடா அந்த சட்டத்தை கொண்டு வந்தான்னு. அது எப்படி தெரியும்? Plain meaning பார்த்தா நமக்கு புரிய போறதில்ல. அதுக்காக என்ன பண்ணணும்? Legislative Assembly debates எடுத்து படிச்சு பார்த்தா அதுல சொல்லிருப்பாங்க. What I can immediately recollect is the amendment to the Code of Civil Procedure in 2002. They brought in the matters were being adjourned regularly. When Mr. Ram Jethmalani was piloting the bill, he said, this is what I brought the legislation for. Using that, you can understand, that is, the debates in the Parliament or the Legislative Assembly will give you an idea why the law came about. Once you understand why the law came about, you will understand the purpose. Once you understand the purpose, then you can bring in contextual. இந்த விஷயத்துக்காக தான் இது கொண்டு வந்தாங்க அன்னி தேதியில. இன்னி தேதிக்கு situation, you can't expect a legislation every month. Therefore, you have to give some flexibility to the words. So you understand the purpose from the debates, thereafter you apply. See, an example is, the recent example is the Right to Disabilities Act. The Right to Disabilities Act, the person might be interpreted, this word disabled, now they are called differently abled. Originally they were called disabled. This word can be interpreted to include all assistive technology and services, even though not specifically mentioned. You will find a recent judgment of Justice G.R. Swaminathan. This is an example I could see. Under the Persons with Disabilities Act, the child wanted to write the exam. There are certain things called benchmark disabilities. The Act itself says, if a person is suffering from these benchmarks, then he is entitled to what you call, if you sit on a computer for a very long time, you develop something called the carpal tunnel syndrome. The entire portion starting from the wrist till your elbow will be enlarged, and it will be a very painful experience. So this is not something which was inborn. This came by virtue of excessive use of the keypad or the computer, or you will have a neck pain. This will not be a benchmark disability, but a case like this comes to you. Certain persons suffering from disabilities are given extra time to write exam. For half an hour time, they are given, assistance of a scribe. You can dictate to the scribe will translate. Now, if a person comes to you who is not suffering from any of these disabilities, but any of the disabilities defined by the Act, but he is actually, he is suffering from pain on account of this fact. The minute he comes to you, a court cannot say, unoda problem vandu inda sattathla cover ala adanaala na kudukka maten. The purpose of the legislation is to see that persons suffering from disabilities are not put at disadvantage as against normal persons. So you should interpret the law looking at the purpose of the legislation and grant the relief to the person even though he is not covered under the legislation. Now, this takes it to the advantages of purposive school. It aligns with the legislative intent. It is adaptable with time. It is comprehensive in understanding. What are the disadvantages again? Please, what are the disadvantages? Subjectivity. Then, excellent. Then, uncertainty, because why? Uncertain because flexible. Person-oriented interpretation. And finally, this gives, taking off from what you said, this gives room for judicial activism. The last of the schools is purely contextual interpretation. This gives a clarity and precision to the Act, gives a clarity and precision. It specifies the applicable law and jurisdiction, and finally dispute resolution. Now this deals with the several schools broadly. Now I'll take 2 or 3 examples to deal with this. How do you interpret criminal law? Criminal law must be interpreted as strictly as possible. The benefit of doubt must be given to the accused. Now, the matter is still before the Supreme Court, a review is going on, PMLA Act, where the Parliament says the burden of proof is reversed. Normally, it is the prosecution which should prove the guilty. Now, we go to interpretation of the Parliament has reversed the aspect of burden of proof. So, unless and until it is an exception, the normal rule is benefit of doubt must be given to the accused. There is a very interesting development in this also. When you come to interpretation of taxing statutes, benefit of doubt must be given to the assessee. If there are 2 things, the tax is a demand of the sovereign. A new tax is imposed. There is some doubt. Then the interpretation that the court must apply, any of these schools, or of the 5 schools I said, is it must be given to the benefit of the assessee. Just like you give the benefit to the accused. Then, the burden of proof is, when it comes on taxing statute, must be so interpreted, it is not unduly on the assessee. If the court can give an interpretation in favor of the, court should always give an interpretation in favor of the assessee in case of a doubt. You come to a conclusion, yes, this is taxable, but if there is a room given to the court or to a lawyer to interpret it in favor of the assessee, even the burden of tax, the interpretation must go in favor of the assessee. Then the principle, the last principle is, we must look at the substance and not at the form. Now, the example is, this is, you can see the judgment of Vodafone Holdings. It's a very complicated judgment, even but I hope, I'm sure that the kind of bright students that you are, you will understand it easily. The judgment is 2012 6 SCC 613. The principle of substance over form is regularly used in taxing statutes, where the actual nature of transaction is seen rather than their formal description. The court removes the smoke screen and sees என்ன காரணத்துக்காக இந்த transaction கொண்டு வந்திருக்கிறாங்கன்னு. Once they understand the transaction, the court places the transaction next to the statute. If it is covered, they are liable for tax. If it is not covered, then they are let go. Anyway, any doubts? So the next I'll move to a very interesting aspect on interpretation of the Constitution. I'm just touching upon it. When it comes to part 3, the fundamental rights, interpretation must be in favor of the individual, because the principle is the state shall not make any law. But when it comes to directive principles of state policy, there must be a broad reading so that Article 39 and 39 are... Solba.
Good afternoon, sir.
Good afternoon.
Sir, unnatural offense IPCல இருந்துச்சு, இப்போ BNSல இல்லைல்ல சார். நவ்தேஜ் சிங் வர்சஸ் யூனியன் ஆஃப் இந்தியா கேஸில் இன்கேஸ் அது கன்சென்ட் இல்லாமல் பண்ணால் அதுக்கு பனிஷ்மெண்ட் இருந்துச்சு இல்லை சார். இப்போ பிஎன்எஸ்ல அந்த ப்ரொவிஷனே இல்லைல்ல சார். ஸோ இப்போ ஒன்று அதுக்கு ஹர்ட்டில் பனிஷ்மெண்ட் கொடுக்கலாம், இல்லை க்ரீவியஸ் ஹர்ட்டில் பனிஷ்மெண்ட் கொடுக்கலான்னு சொல்லியிருக்காங்கல்ல சார். பட் இது யானை பசிக்கு சோள பொறின்ற மாதிரி இல்லையா?
இல்லை, அதுதான் சொல்கிறேன். கோர்ட்டோட வேலை கிரிமினல் லாவில் ஒண்டி பிஃபோர் இந்த பார்லிமெண்ட்லாம் வரதுக்கு முன்னாடி நீங்கள் ஹிஸ்ட்ரி பார்த்தீங்கன்னா there used to be something called ஸ்டார் சேம்பர். அந்த ஸ்டார் சேம்பர் தான் இப்போ இருக்கிற ப்ரீவி கவுன்சிலோட ப்ரிடிசிசார். அந்த 4 ஜட்ஜு நீ பண்ணது கரெக்டாக தப்பாக உன்னை ஜெயிலுக்கு அனுப்பணுமா வேணாமான்னு சொல்லிக்கிட்டு இருந்தானுங்க. அதனால தான் கிரிமினல் லாவே வந்தது. ஏன்னா 4 பேர் சொல்கிறத வச்சு உன்னை நான் ஜெயிலுக்கு அனுப்ப முடியாது. இப்போ எனக்கு மூஞ்சி பிடிக்கல, நான் உன்னை ஜெயிலுக்கு அனுப்பிச்சிடுவேன். அந்த தம்பியோட மூஞ்சி பிடிச்சிருக்கு, அவனை வீட்டுக்கு அனுப்பிச்சிடுவேன்னா. ஸோ there is no certainty. That is why the legislation has come in. இதில் தான் purposive interpretation பார்க்கணும். 377 ஸ்ட்ரைக் டவுன் பண்ண ரீசன் என்ன? ப்ரைவசி, ரைட் டு ப்ரைவசி. பார்லிமெண்ட் பிஎன்எஸ் அந்த இப்போ இது வாட் எவர் தட் நியூ ஐபிசி கொண்டு வரச்சே, they were aware parliament is deemed to know all the legislations, all the judgments. This is one principle of law. இப்போ பார்லிமெண்ட்டுக்கு நவ்தேஜ் ஜட்ஜ்மெண்ட்டும் தெரியும், அதுக்கு முன்னாடி போட்ட அந்த நாஸ் ஃபவுண்டேஷன் ஜட்ஜ்மெண்ட்டும் தெரியும். தெரிந்திருந்தும் இந்த சட்டம் கொண்டு வந்திருக்காங்கன்னா, இப்போ என்கிட்ட இன்டர்பிரிட்டேஷன் வந்ததுன்னா பர்பசிவ் ஸ்கூல் அப்ளை பண்ணி எப்படி இருந்தது, எதுக்காக மாறிச்சு, இப்போ எப்படி இருக்குது, நான் சொல்கிறது புரியுதா? 377 எப்படி இன்டர்பிரேட் பண்ணாங்க, நாஸ் ஃபவுண்டேஷன் எப்படி வந்தது, நாஸுக்கு அப்புறம் நவ்தேஜ் வந்தது, இப்போ இந்த பார்லிமெண்ட் புது சட்டம் வந்திருக்கு. அதனால் இப்படி தான் நம்ம இன்டர்பிரேட் பண்ணணும். லிட்ரல் ஸ்கூல் அப்ளை பண்ணால் நீ சொல்கிற மாதிரி தான் ஆகும். ஹர்ட்டுக்கு கொடுத்துட்டு இவனை இதில் விட்டுற வேண்டியது. தட் இஸ் நாட் த பர்பஸ். இஃப் 2 adults of consenting age have given their consent and indulged in sexual intercourse which is even considered by the society as unnatural, law must keep away as the principle. Liya, we have to see how the parliament has interpreted it. Thank you, ma'am.
So due to time constraint, we just permit only one student, and somebody also raised the choice to want to meet the Lordship. So after this session, we requested Lordship to address those queries. Those who are interested can meet Lordship and get the clarification for your queries. So I request Harini to give the word of thanks for resource person, Hon'ble Lordship Thiru Lakshminarayanan sir. Before that, we are continuing the next session immediately. After that, we will have the tea break. So after tea break, we will directly commence the valedictory session. So no break now. Continuously, we are going for the next session also. So Harini, just propose a vote of thanks.
Thank you, ma'am. So firstly, I would like to extend my heartfelt gratitude to Justice Lakshminarayanan, Judge, High Court of Madras. Thank you so much, sir, for brushing upon the entire subject matter of interpretation of statutes within a short period of time. I think all of us would have got a clear picture of what IOS is, the basic foundation. Thank you so much for this, Lordship. Thank you so much for coming and joining with us on a Sunday afternoon. And in fact, After such a heavy lunch, your class was as interesting as it could be. Thank you so much, Lordship. So with this, we come to the end of this session. I request the audience to kindly stay back as we are going to continue with the last session of this workshop after this.